Get ready for the dictation. Start. In view of the fast and constantly increasing volume of traffic, motor vehicles upon roads may be regarded to some extent as coming within the principle of liability defined in Reliance versus Fletcher, within bracket 1868 3HL within bracket LR 330 stop. From the point of view of pedestrian, the roads of this country have been rendered by the use of motor vehicles, highly dangerous stop. Hit and run cases where drivers of motor vehicles who have caused accidents, are unknown stop. In fact, such cases are increasing in number stop. Where a pedestrian without negligence on his part is injured or killed by a motorist, whether negligently or not, he or his legal representatives, as the case may be, should be entitled to recover damages if principle of social justice should have any meaning at all. Stop para. These provisions bracket open section 110A and section 110B of Motor Act, 1988 bracket close are not merely procedural provisions. Stop. They substantively affect the rights of the parties. Stop. The right of action created by Fatal Accidents Act, 1855 was new in its species, new in its quality, new in its principles. Stop. In every way it was new. Stop. The right given to legal representatives under Act, 1988 to file an application for compensation for death due to a motor vehicle accident is an enlarged one. Stop. This right cannot be hedged in by limitations of an action under Fatal Accidents Act, 1855. Stop. New situations and new dangers require new strategies and new remedies. Stop para. In the light of the above discussion, we are of the view that even if courts may not by interpretation displace the principles of law which are considered to be well settled and, therefore, court cannot dispense with proof of negligence altogether in all cases of motor vehicle accidents, it is possible to develop the law further on the following lines, when a motor vehicle is being driven with reasonable care, it would ordinarily not meet with an accident and, therefore, rule of res ipsa loquitur as a rule of evidence may be invoked in motor accident cases with greater frequency than in ordinary civil suits, bracket open, per 3 judge bench in Jacob Matthew versus State of Punjab, 2005 0 ACJ within bracket SC 1840 bracket close. Stop para. By the above process, the burden of proof may ordinarily be cast on the defendants in a motor accident claim petition to prove that motor vehicle was being driven with reasonable care or that there is equal negligence on the part the other side. Stop para. The Apex Court in Chennai versus New India Assurance Company Limited and others, 2015 lawsuit within bracket SC 469 has held as under colon para. It is a case of composite negligence where injuries have been caused to the claimants by combined wrongful act of joint tortfeasors. Stop. In a case of accident caused by negligence of joint tortfeasors, all the persons who aid or counsel or direct or join in committal of a wrongful act, are liable. Stop. In such case, the liability is always joint and several. Stop. The extent of negligence of joint tortfeasors in such a case is immaterial for satisfaction of the claim of the plaintiff oblique claimant and need not be determined by the court. Stop. However, in case all the joint tortfeasors are before the court, it may determine the extent of their liability for the purpose of adjusting inter se equities between them at appropriate stage. Stop. The liability of each and every joint tortfeasor vis-a-vis to plaintiff oblique claimant cannot be bifurcated as it is joint and several liability. Stop. In the case of composite negligence, apportionment of compensation between tortfeasors for making payment to the plaintiff is not permissible, as the plaintiff oblique claimant has the right to recover the entire amount from the easiest targets oblique solvent defendant. Stop.